A very good afternoon to Miss Lavanya. Today, me and my group members, which are me, myself, Kirti, the group leader. Second, which is Julian, followed by Saltanat, and also lastly is Xu Tianwei. We have chosen the case law, which is Tan Sri David Chiu Tat Cheong versus Seema Elizabeth Soy from the year 2024. And based on the topic we have given, that is online defamation in a private WhatsApp group. So now we will look into more about the introduction of the case law and try to explain what is the case law about in short. Now, let's look into the introduction for this case law. As I have mentioned earlier, the case law, which is Tan Sri David Chiu Tat Cheong versus Seema Elizabeth Isoy from the year 2024, is actually about an online defamation in a private WhatsApp group where the defendant Seema Elizabeth Isoy accused the plaintiff Tan Sri David Chiu of an unethical conduct by bringing out his past fraud charges but also omitting his acquittal. And this omission, termed a half-truth, misleads readers and also implied malice, where the federal court actually ruled that advising others to Google the details did not mitigate the defamatory effect, where the court also relied on the Defamation Act of 1997 and the precedents like the GS Realty Sendirian Berhad versus Lee Kong Sang actually emphasizes that incomplete digital statements could actually harm reputations and also constitute defamation, where this ruling underscores the importance of context and intent in digital defamation claims. Now let's look into identifying the plaintiffs and also the defendants in the next slide. Now, in this slide, we'll be looking into the characters involved in this case law. That is the plaintiff Tan Sri David Chiu Tat Cheong, whom is a notable Malaysian businessman and a chairman of a property. He actually initiated this defamation claim where he argued that the defendant's online posts in a WhatsApp group damaged his reputation by implying guilt in fraud charges and also omitting his details of acquittal. Whereas the defendant Seema Elizabeth Soy, a member of the private WhatsApp group where the plaintiff was also present, has actually posted about Chiu's legal issues without acknowledging his permission, and this omission was alleged to create a misunderstanding and misleading and defamatory impression, leading it to reputational harm. So that is all from me. We will look more into the details of the case laws with Julian and also rest of the group members. Thank you.
Hello there everyone, so my name is Julianne and I'll be talking about my part, which is the facts of the case law. So the first one will be allegations by Seema. Seema made a statement accusing Chiu of being involved in past criminal charges. However, in doing so, she deliberately left out the critical detail that Chiu had been acquitted of those charges. This omission significantly altered the context and could lead to a false or misleading perception of Chiu's character and conduct. Chiu's claim, Chiu argued that Seema's statement, especially due to the omission of his acquittal, carried an implicit meaning that he was a dishonest and fraudulent individual. This implication, according to Chiu, defamed his character and reputation, suggesting a lack of integrity despite his exoneration in the criminal matter. The third one would be Seema's defense. In response, Seema maintained that her statement was truthful. She argued that the criminal charges against Chiu were factual even if the outcome was omitted. Secondly, fair comment. She contended that her statement was an honest expression of opinion on a matter of public interest, not intended to harm Chiu too. Privilege. Seema claimed the statement was made in a context that granted her a legal right or protection such as reporting within a judicial proceeding or underqualified privilege. So next, it will be legal issues around in the case law. There are 5. The first one, which is defamation. So it was the WhatsApp messages defamatory due to its half-truth? Did the omission of Chiu's acquittal create a false and damaging impression? Then the second one, defenses to defamation. Justification. Was the statement substantially true? Doctrine of half-truth. Can a statement be defamatory if it omits the key facts even if parts are true? Fourth, use of foreign common law. Can Malaysian courts rely on foreign principles like half-truth to address gaps in local defamation law? And lastly, fifth, Defamation Act 1957. Section 8 and 9, how do justification and fair comment apply to incomplete or misleading statements? And that's all from my part. Thank you.
Hello everyone, my name is Sultanat and today I'm going to present principle of laws. First one is defamation. The plaintiff must provide evidence to support his claims. Its words are defamatory, words refer to plaintiff, and words are published. And the second one is defenses under Defamation Act 1957. Justifications. According to justification section A, statement must be substantially true. The second one is fair comment section 9, protects opinion on public interest if facts are true. And the third one is qualified privilege, applies to statements made in a good faith on privileged occasions unless malice is shown. The third one is doctrine of half-truths. Key factors should not be missed as the statement may appear defamatory as it creates misleading. Use of foreign common law. According to Section 3 of the Civil Act, Law 1956 allows reliance on English common law where Malaysian law is silent. The plaintiff. In the case of Chong Shing Jen, Government of State of Sarawak, the plaintiff claimed that the defendant's half-truth statement shared in a WhatsApp group were defamatory under Malaysian defamation law, especially the defendant omitted the plaintiff's acquittal from their statements, creating a misleading narrative that implied dishonesty and fraud. The court agreed, ruling the statement defamatory because the omission of key facts gave a false impression. About the defendant argued that the defenses of justification, qualified privilege, and fair comment applied. However, drawing from the precedent in Lim Guan Eng and Utusan Melayu, the court highlighted that half-truths cannot be protected as truths. The defendant's omission of acquittal demonstrated malice, rendering the statement both misleading and defamatory. Consequently, defenses failed as the incomplete truths misrepresented the facts.
Today, I will analyze the Quota Bureau judgment in light the Job Bees Guidance 1963 or 3 or ER 952 and Shou Chuan Sen v. CTOSEMR STMBHD 2003 4 MLJ 180. The quota have consistently emphasized in the ordinary the natural meaning of words include the implied or inferred meaning as interpreted by a reasonable person. In George B. Skelton, it was established that even omissions, such a half-truth, can convey defendant impairment if they mislead the audience. This principle was reaffirmed in Shou Chuan Sen v. CTOSEMR, where the court held the half-truth statement as meeting defendant's critical misleading and harm the defendant's reputation, satisfied the context of the defamation. The omission also demonstrated malice, invalidated defendant's defenses. The plaintiff was awarded Rm 100,000 in damages and a permanent injunction. In conclusion, Malaysia law underscored the half-truth as harmful and was outright falsehood. It was essential for the individual organization to communicate responsibility. While legal framework should modernize defamation law to reflect the new unhealth caused by misleading statements. Thank you.